Hey, I'm Luke Bradley. I'm a partner at Bouhan Falligant in Savannah, Georgia, and I concentrate my practice on federal and appellate litigation in all the courts throughout Georgia. I'm making this video today to share 5 things to avoid when writing for federal district courts. Now, this isn't substantive writing advice. Plenty of people have done that very well. Brian Garner, Ross Guberman, among others. These are little nuts and bolts things that can make your motion far less attractive to district court judges and that you subsequently obviously want to avoid. Number 1, you should avoid referring to your motions only by their name. Use the CMECF docket number that's generated when you file that motion. So I'm putting up on the screen right now, this is a standard docket CMECF entry sheet. You'll see there's a little 1 next to the complaint. Everything gets numbered when it comes in. And I think this is old hat for people who practice in federal court day in and day out. But if you're there for the first time and if you spend most of your time in state court systems that don't number their dockets, these numbers are the lifeline for federal law clerks especially, because the judge is going to make the decision, but the federal clerks are going to help get the relevant paperwork onto her desk, and those numbers instantly let the clerk know exactly what you're referencing. So tip number 1, avoid referring to your motions only by the name of the motion and omitting the number. Tip number 2, piggybacking on that, avoid numbering your exhibits using letters instead of numbers. So I think it's a bad idea to have Exhibit A, Exhibit B, Exhibit C, because if you have 2 or 3, that's fine, but take a look at what I'm putting on the screen right now. These are motions that I filed in a case several years ago that we just got an appellate victory in after getting a victory in the district court as well. You've got 3 motions, 2 of them with about 25 exhibits and 1 of them with about 12. Now, quick, without looking at anything, what ordinal number corresponds to the letter O? I don't know. Most law clerks don't know. So if the law clerk sees Exhibit O in your motion, she's going to have to sit there and go, A1. Don't do that to her. Just use the number. So she's going to say, okay, Exhibit 22, because then it's going to get Bates labeled or CMECF labeled as 54-22, and when she reads it in your primary paper, she's going to say, oh, perfect, I'll go there. So that's one more way of making life easier for the law clerks and the judges to the extent that they're navigating PACER and not just relying on paper copies. Number 3, know your local rules that implicate mechanics. Now, I think that it's kind of old hat at this point that you should know the local rules and the local rules are important. But I think that people pay attention to the substantive local rules and sometimes forget to pay attention to the little logistical local rules that can cause a nightmare on the day of the filing. So for instance, filing under seal. We frequently serve as local counsel in big complex cases that are, usually implicate businesses. And so a lot of documents are inevitably being filed under seal. One of the first things that we'll say is, if you need to file things under seal, we need to talk about timetables. Because, at least in our court, filing things under seal is a manual physical process that has to be done when the clerk's office is open. And there are some workarounds, but you don't want to be in a position where you're relying on them. And it's not something that jumps out at you in the local rules, but you need to know it because otherwise you'll be sitting there at 10:30 p.m. on the day that your filing is due, calling local counsel and saying, well, where's the checkbox for filing it under seal, and hearing, a concerned, panicked silence on the other end. So don't do that. Either retain local counsel or really pay attention to those little pain point local rules that can make the logistics of your case either super easy or a nightmare. Number 4, formatting your documents properly. Now again, this is not revolutionary advice, but I think it bears repeating for people who did not have an opportunity to clerk in a federal court how much paper is hitting your desk every day. When I was in the Southern District, which is not, it's not the Southern District of New York, it's not the Northern District of Illinois, it was the Southern District of Georgia. And we still had 400, 500 CME-CF hits per day come across the screen. And because in a district like ours you have fewer judges, a significant portion of everyday CME-CF hits is going to land in your judges' chambers. And so at that point, when you have competing motions and neither of them are searchable, and they address each other's points out of order, and there are no tables of contents, it's enough to make you tear your hair out, because you know that there are 25 other motions waiting that have to go out in the next 2 months, and you just really wish that the parties had given you briefs that were malleable and that you could work with. So think about anything that will make your brief easy for the law clerk to manipulate and read. Searchability, really clean PDFs, hyperlinks if necessary, tables of contents, addressing things in the order that your opposing party did, or explaining to the court early in the brief why you're not and what order you are addressing them in. Those are going to go a long way towards making your motions far more readable and thus far more easy to grant. Number 5, and I think this may be the biggest one in district court, is request your relief exactly and with precision. And to do that, you have to know what relief you need. And that sounds silly, but in the courts of appeal, you either want to affirm or reverse. Sometimes you have strange procedural quirks, but oftentimes what you need is very simple, even if convincing the court to do it takes a lot of work. And same thing in the district court for something like a motion to dismiss or a motion for summary judgment, where we're all familiar with Rule 12 and Rule 56. We understand what we're asking the court to do there. But sometimes you're going to be asking the district court for relief that is not standard, not summary judgment, not motion to dismiss, and you need to know exactly what you want. Now, in motions to compel, this takes the form of knowing exactly which interrogatory responses and which requests for production the other side needs to supplement and how they need to supplement them. I think tables are great for that. You need to give the court something that this poor magistrate judge siphoning through your discovery request can latch onto and actually use to grant you relief. And this, what I'm putting up on the screen right now, this was a motion that we filed to have a client's property released from the care of the court. And to get this done, it involved a piece of paper being generated in the district court's office, going up to the clerk of court. It required several different signatures. And we had to research this process on the front end and make it very clear in our filings with the court which people in the building had to undertake which acts and generate which forms to finally get this done. And that sounds obvious, but you would be amazed when you are a law clerk how many things cross your desk where somebody says, "Judge, help me." And the implicit reply question is, "Okay, how do we help you?" And the answer seems to be, "I don't know, just help me." You have to give the judge the tools to know what she needs to do to give you your relief. And if you don't understand how that's going to work, you should not be asking her to figure that out. So I think that that's perhaps the most important thing, and as a bonus, it clarifies your substantive writing, because once you truly understand what you need and how the court gets there, then it becomes relatively easy to write the motion. But if you don't understand that, you are guaranteed to be writing gobbledygook. So those are 5 things to watch out for and avoid in writing for district courts. I hope it's been helpful, and I hope to see y'all out there.